a hacer contar con la experiencia y la visión de estos dos expertos en materia de implementación de tecnología en los sistemas judiciales. Voy a partir presentando en el orden en que van a hacer sus exposiciones. En primer lugar, les voy a presentar a Dori Reiling. Dori es juez de Tribunal de Primera Instancia en Ámsterdam. Ha sido... Bueno, y ha trabajado en varios proyectos, tanto en Ámsterdam como consultora del Banco Mundial, como una experta en materia de reformas judiciales e implementación de tecnología.
I'm sorry.
No, we are sorry.
And I'm wet. It's okay. I'm not very sorry. You are wet.
Wine or coffee? At least water. There is not wine. Yeah.
It's okay. Things happen. I don't think anything really serious happened. Just that we get wet and that takes care of it.
Bueno, como decimos por aquí, alegría, alegría. Bueno, entonces, habiendo con esta accidentada presentación de Dori Reiling, sin más, si es que tú sí que estás, ¿ok?
Okay, yes.
Dejo con usted entonces a Dori Reiling. Por favor.
Okay, thank you. I would like to stand up, so if someone can give me one of the mobile microphones.
Yeah.
Now it should be on, and it is, yes. Let me say, first of all, that it is a great privilege for me to be here. This is my first time in Chile, and you can see I have a little bit of a sunburn. Now, that is because my husband and I walked yesterday all morning in the Seminario General because it was Victor Jara's birthday, and we found his grave. So it's a real privilege for me to be here in Chile now, just after Victor Jara's birthday. And you know, it's very strange because we never realized that for you, 1973, September was spring. For us, it's autumn, so we are used to things dying down and slowly stopping. But for you, it must have been a very different feeling because it happened in spring. Anyway, so I enjoy being here. It's my first time. But that's not what I'm here to talk about. I am here because I wrote a book on technology for justice, and I'd like to talk to you a little bit about how that book came about and what is in it and what may be useful for you. So it's the title of my presentation. This is a picture I took when I worked in Sri Lanka. It is a court building, and under the cloth you see there is a computer. And what we're going to do in the coming 30 minutes is to find out what is under the cloth and also what is behind the cover of my book. First, a little bit about how actually the book came about and how I did the research for the book. What about the IT for the courts? And what the three most major, no, I have it here, thank you. What the three major complaints of court users are that I used as the basis for my research, and what that can mean, what significance that can have for rule of law projects. So, but first I'd like to introduce myself just a little more, because that means you will understand why I was the person who wrote this particular book. I became a judge in 1986, that's a long time ago. And I got my first computer 2 years later, in 1988. And maybe for a second you would like to think back to the moment when you got your first computer. How long ago was that? And what could it do? Mine couldn't do very much, because it could do text, but nothing much else. We certainly did not have the internet or anything yet. Since 1993, that's another 5 years later, I've been involved in court automation at the national level in the Netherlands. And from 1999 on, I was in charge of the ICT program for the Dutch judiciary for a while. In 2004, I moved to the World Bank in Washington because they needed someone with all the technical projects they did for judiciaries in developing countries using IT. They needed someone who had a little bit of experience with policy making. So I moved to the World Bank. I worked there for 3.5 years, and I learned a lot about judicial reform, but also about how to approach IT and how to translate user needs into IT solutions. Then my contract ended and I went back home to be a judge again. But the Judicial Council of the Netherlands said, your experience with the IT in court has been so special, we would like you to write a book about it. So they paid for a little bit of my time for 3 years, and that enabled me to write the book. And actually I got a PhD for writing the book. So that's the history of what went into the book. And now a little bit more about how this girl went about finding the conclusions that I will present to you at the end. My plan was, and I'll step down just a little bit so I can read it. My plan was to investigate IT and I have to look at the English, I must say. I have one English version here to help me through the process. And I have to... My plan was to write about IT supporting reform goals. And in order to do that, I had to distill reform goals for justice systems based on what the most frequent user complaints are. Nobody ever does that, because usually this is not what you get paid for if you work in IT or in judicial reform. But since I was free to write my own book, I decided these were the most important things to do. Find out what users complain about and how IT solutions can maybe remedy those complaints. So that's what I did. That was my plan. But then I told you, I became a judge again, went back to my own court, and I had discussions with my colleagues about court IT. And that changed the plan. As I said, it changed the plan. Because quickly, I realized that when we talk about IT, we talk about IT very easily. But what is it? So what my book needed was a chapter on what IT actually is and how the courts use it, because they use different kinds of IT for different things. And so my first question was, what IT do we actually use? And for that, I used investigations that were done in Europe with regard to the level of IT use and implementation. So that's the first thing I would like you to take a brief look at. This is the level of implementation of IT intended for direct use by judges and their staff. And based on European research in this field done by a commission working for the Council of Europe, the red countries report themselves that they have a very high level of this kind of IT. What we're talking about is document production, that is, courts produce documents. That's what their business is, isn't it? So document production, databases with jurisprudence, and email and internet use by the staff in the court. So that is not the use of websites for external purposes, but just whether the judges and the staff have access to the internet from their workspace. And so you can see there are that the distribution is quite different. There are countries that have a fairly high level of implementation of this kind of IT, and there are also countries that are behind. But on the whole, most courts in Europe have this kind of functionality. But as I said, that was not digital communication. Now we talk about digital communication between the courts and the court users and the general public, and we see a different picture because there are far fewer red countries here than there were in the first picture. So I'm going to leave it at this because I have a lot more to tell you. My second question arose from discussions with my colleagues, and that is, why is IT in courts so difficult? Everybody says, it's difficult, why does it take such a long time? So I thought that was an issue that should be addressed. And I looked at a lot of IT projects, government projects, other IT projects, and I came to some conclusions about why IT for courts is so difficult. And one thing we have to keep in mind, and I'm sure most of you already know that, is that IT is always difficult. IT projects are always more complicated than we think, and they take longer because there is all sorts of complexity involved that we cannot foresee. That is simple reality. We also know that government organizations have to do with more complexity than private firms, because they only have their own framework to deal with. A government organization has to deal with parliament, with budgets, with political priorities, all sorts of things. So that's also added complexity. What is particular is legal culture. And let me go into that for a second, because it's something we do not often talk about a lot, but it is a factor which complicates thinking about technological issues and about what we actually do in the world. Legal culture, if I work in my court, basically what I do is that I look back at something that happened in the past, and it is my task, generally, try if that is true for you as well, to decide who to blame for what went wrong. So basically what judges do is to look back. And for deciding what went wrong and who's responsible for it, we also use precedent. We use jurisprudence, things that also happened in the past. So looking forward is not the core business of the judicial system. Looking backward is. And that really makes thinking about IT and projects and doing and reform difficult, because that's not our basic frame of mind. We also discovered, at least in the Dutch judiciary, that a governance structure that was set up to manage a paper-based organization can be much lighter than an organization that has to manage information and IT-based judicial systems. And what we see now in the past, say, 10, 15 years is that in Europe, governance systems of most judiciaries have changed dramatically. And my theory, but I still have to prove it, is that most of those changes were done because using IT necessitates a different kind of organization. Maybe that is what my next book should be about, if someone pays me to write it. And the other thing that is difficult, that is logically follows from all the others, is that there is not a lot of know-how about IT and about information systems in the judiciary. So that's why it's so difficult. Those are not things that you can easily blame someone for. They are just facts of life that we have to manage somehow. All right. Having done that, we can now go back to the most common complaints. And particularly from my time at the World Bank, my conviction, but I think I have now also demonstrated it, is that the three most common complaints about the judicial system are the following. That is delay, lack of access, and corruption. Now, my colleagues in the Netherlands are always a little worried when I talk about corruption. They say, we don't have a lot of corruption here. I know that in Chile you also don't have a lot of corruption. But from what I understand, I looked at the transparency figures yesterday, and it is a little bit on the rise, so it is, I think, a point of concern. What are the most important internal translations for these three problems? One is internal processes are a major cause of delay. If we look at lack of access, we talk about interaction with the user, and if we look at corruption, we talk about how to preserve the integrity of our organization. So those are the three main issues that the rest of my book is about. And actually, I remember that about 15 years ago, when I talked to my colleagues about these things, they would say, but we are independent. And who is going to tell us what to do? And I discovered very quickly that the best way to deal with that is to say, but it's in the law. These quality norms for judicial work are in the law. And just as an example, this comes out of Article 14 of the International Convention on Civil and Political Rights. And it says that there has to be a fair and public hearing within a reasonable time and before an independent and impartial tribunal. And there you have your three aspects on the other slide again. So, it's in the law. And that worked like a charm, because if you tell judges something is in the law, they will believe you. And they will no longer discuss whether it's a merit or not. So, for each of those three problems, I looked at what factors are involved and whether they exist, how to establish that the complaint actually exists in reality. I looked at remedies, preferably proven remedies, because then you know it's going to work. And I looked at information aspects for each of those solutions. And then I looked at proven technology that could help resolve it. I'm going to skip this one, because you will see of its own how that works. And so my first part 3 of my book is on delay. And I'm going to skip about 2/3 of what I wrote on delay to show you this, because this is an illustration of how courts process information. You see, this is a matrix, and what I'm going to do is to classify the cases in a court according to relevance for managing the cases. So you see here, an important factor with regard to how long a case takes is how unpredictable the result is, the result being the judicial decision. Maximum uncertainty about the result is in this corner of the matrix here. And here you see where the question, are parties cooperating? That is not a very normal way of looking at court cases, because we are used to parties being antagonistic. But in fact, in a lot of cases, parties can achieve a much better result if they cooperate. Think of mediation, think of a lot of family cases. So that level of cooperation that can achieve the best result is on this side, with the maximum down here. If we look at this, we can actually make a classification of the kind of cases that a court deals with. If, for instance, we look at this corner here, this is what I call group 1, has a result that is predictable, and there is very little cooperation between the parties. Think, for instance, money claims. You say you owe me money, you go to court, and I don't contradict that. It means that you have an undefended claim, and the court is going to grant it. That would be in this group. In this group, a lot of cooperation, but also predictable result, most family cases, because the outcome of most family cases is not so unpredictable. becomes a little different if we move to the right in this matrix, because here parties cooperate, but the result they're going to achieve cannot be predicted from before, because it depends on things that happen in this process that goes from here to there. But this is the kind of situation where we see settlement in court. That is in this group. And that leaves us with this group here. That is where the result cannot be predicted, and cooperation between the parties is not going to determine what the result is. And actually, this is what we mostly tend to think of as judicial work. So, if what judges really do is in group 4, but we also have these other 3 groups, how is the distribution of cases over these 4? I did that. I counted for about 5 years of Dutch judicial statistics. I counted how many cases come in each group. Now, you need a very sound, solid case classification system. So we have a system where I can see from the number of the case what kind of case it is, if it is a simple family case, if it is a divorce, whatever. We have that, and because we have it, I can do this. So don't think you can do it just like off the cuff, because that's not how it works. But it's very interesting and it's very informative. So, 35% of all cases come in the first group. In the second group, 30%. And this is a constant over the past 7 years in the Dutch court. So we think it's probably, unless major economic disaster happens, this is a distribution that's constant. We also see that in the mediation group down here we have 9%, and this group that we think of as what courts do is actually only 8% of the total civil caseload. Who would have thought that beforehand? I certainly didn't, but I was surprised by the result. But it helps to think about RIT, because what does it mean if we have so many cases in this group here? The result is predictable, which means that we know what we do. We do not need parties' cooperation. This is the group with the most potential for automating your internal processes. There's potential in the other groups, but we're coming back to that later. To give you an example of what can be done in this group, and I'm coming back to this later, because I want to show you the example. This is a system that was developed in the United Kingdom, in England, where they have developed a system. It's a web-based system where you can electronically file a money claim. And they have done that on the basis of the correct idea that predictable processes that do not require a lot of user participation can be automated. So that's what they did. Francisco's going to talk a little more about that, so I will leave that for him. But for the moment, this system has been up and running now for 8 years, and it's working well. They are expanding it into other areas. Okay, but I wanted to come back to my arrows, because our original problem was delay. Now, we know from research that was done at the World Bank and in other places that if you want to combat delay, there are 2 things you can do. One, no, that's the wrong direction. One is that you can make simplifications in your process. And what that does is what is shown here by this yellow arrow. It simplifies the number of things you have to do, and that means that the process becomes more predictable. So that's the one thing to the left. The other one is early intervention, and actually early intervention also simplifies because it keeps better control of what happens. But the other one, to be complete, is early intervention. But a new thing that you can do, and that comes from this model, and I don't think that has been tried before, is to enable the parties in a case to resolve more of their own problems. So if, for instance, in a family case you have different aspects that have to be dealt with, and out of the 10, there are 8 that they can resolve themselves with a little help on how to resolve them, that means that the court doesn't have to deal with those issues. So that's what the vertical arrow says, that is moving information, making information available, and thereby moving cases down so people deal with their own problems better. Now that is the access to justice aspect of this slide, and it is the subject of part 4 of my book. And if we skip this one, we can go to part 4. I'm going to skip this one as well, even though it's exciting and interesting. I'm going to part 2. And that's access to justice. So we have just seen that access to justice is something that can actually speed cases up, which means that it deals with complaint number 1. But access to justice, of course, is also a complaint in itself. And I have looked at the different factors that are involved in access to justice, and it's not so difficult to think that there are physical factors. If you cannot get to the court, that is difficult. If you cannot pay for a lawyer, that doesn't help. And the third major factor is information and knowledge. And since I was writing about IT, of course, I looked at information and knowledge, and at solutions that have something to do with that. And in order to find out what information solutions there is, I looked at how people who have a problem actually deal with those problems. There's extremely interesting research in England and in the Netherlands on how people who encounter a problem deal with that. And that helps us understand what kind of information people need to solve their own problems, which was my main question here. And only in the second place did I look at information for court users. So we go back to our matrix, because that helps us understand what for each group the information needs are. And in group 1, we generally see those are money claims, so those are banks and electricity companies and telephone companies who need payment from individual people. Now, the individual people in my model are called one-shotters. They are people who never go to court, who have no idea how it works, and their counterparts in group 1 are organizations that go to court all the time. And they know how, they know what the jurisprudence is, they know the procedures, so there is an information deficiency with the one-shotters who do not know that. In the second group, mostly family cases, we generally tend to see individuals on both sides. So that creates a different information need. And on the right-hand side, the information needs are so diverse that it's very hard to make predictions about those. Now, the idea is that the internet actually causes disintermediation. Disintermediation means, for instance, that 10 years ago, when I needed a plane ticket, I went to a travel agent and they got me a plane ticket, and now I do that myself. I book my own hotels, I get tickets to everywhere online. That is disintermediation. And the question is disintermediation something that can work in the legal field? Meaning that that for a lot of things we will no longer need lawyers but can do them ourselves. So that is the background behind how I looked at what access to justice means when you look at it from the IT point of view. Let me see, where am I in English? Yes. It's important to keep in mind that there are different levels of user interaction on a website. The most simple form is to present information that is static and that the user can read and then act upon or not. There are also more interactive forms of digital communication And the first thing, Ricardo already talked about it, so I don't need to spend a lot of time on this, is downloadable forms. And by now we're all used to downloadable forms. They come in two forms. One is you download the form, you print it out, you fill it out, put it into an envelope and send it through the post. That's the most simple form. And I think most courts by now in Europe would be using downloadable forms. E-filing is a step up because then you also send information back to the court electronically, and the court will have to be able to receive it electronically. My court, the Administrative Court of Amsterdam, has a possibility to do that, but since we do not have electronic files in the court yet, we then print out what came out of our computer and we make a paper file of it. No problem, we can work with paper files. And of course, ultimately, we will do away with the paper files and make them digital. An even higher form of interactivity would be to give people access to our case management systems so they can manage their own cases. That's possible. I don't think that has been implemented anywhere yet. I'm going to a conference in the US next week where 2 years ago they told me that they were experimenting with direct case management, but I'll be interested to see how far they are by now. And that would also, of course, involve access to the court systems. One thing, however, should not be forgotten. All research about how people deal with their legal problems shows that there will always be people who need human help. In the Netherlands, about 10% of the population is not literate enough to participate in modern life. And if you think that is a lot, think again, because in the UK it is 20%. 20%, 1 in 5 people is not literate enough to participate in modern life. So if we want to make sure that these people have access to justice, they will need human help. And that will not change, I think. Okay, we're skipping this one because we had everything. Just a little bit about the integrity. Some factors are involved in whether there is corruption in a system or not. And those factors all more or less, 3 minutes, more or less apply to courts, because courts have a monopoly and they have a margin of discretion. So there is always a risk that there will be corruption. Corruption comes in different forms. That is what the last transparency slide shows. This is one I did particularly for people who do not understand that corruption comes in different forms, so I think I can skip that here. And what form of corruption your system has also determines which forms of IT can actually improve the situation in your country. So if you want to read my book about that, where are we here? Just some conclusions. I have 3 slides with conclusions, so I will use 1 minute for each, and I hope I will be done then. What can we learn? Case registration systems are incredibly important. If there's only one thing you can do, get yourself a simple, clear, good working case administration system, because it's going to tell you everything you need to know for your next step. So that's very important. What you can do is determined pretty much by your local situation. What your problems are is going to tell you what kind of IT should come first. That is not in contradiction with Rule 1, though. 3 is to learn from experience. If I go for a second back to the money claim online system, they started with an experiment that had been going on for 10 years, and they added on to that system every time they learned something new. And they expanded it into other areas. Learn from experience and do what you know how. Don't try to do what you don't know how, is the counterpart of that rule. Looking back at what I told you, the 3 issues are all related. So doing something about delay probably also means you are doing something about access and about corruption. I think that is the main thing for this one. And I have some specific IT conclusions. The starting point, depending on your problem, but the major starting point is office automation is your first step. And a good case registration systems will reduce disposition times of cases. And my last point is that network technology can increase your transparency, not just internally, but also your external accountability. But you do need a governance structure that is suitable for managing your organization, and you have to take into account that the legal culture is not very friendly to IT systems and to an IT-based organization. And I think before Ricardo gets really nervous, I will leave it at that. I'm happy to answer more questions, and I have another presentation that if you're more interested in depth in my access to justice thinking, I'll be happy to share with you at some point if that's what you would like. And thank you very much.
Bueno, junto con agradecer la presentación de Dori, que creo que es sumamente útil más en el contexto de nuestros países que estamos en plenos procesos de reforma en materia civil, y creo que es sumamente relevante tomarlo en consideración. Y a continuación, muy rápido, voy a presentarles a Francesco Contini, quien es investigador del Research Institute on Judicial System del Consejo de Investigación de Italia, en Bolonia, desde 1996, que es investigador. Su principal foco de investigación son los procesos y los cambios y procesos institucionales en materia de tecnología en los sistemas judiciales, y el análisis de políticas o el diseño de políticas para mejorar el acceso y la calidad de la justicia. Ha trabajado como consultor en el Banco Interamericano de Desarrollo, para el Consejo de Europa, entre otros proyectos de implementación de tecnología, entre ellos uno que es muy interesante, que es sobre la construcción de interoperabilidad para los procedimientos en línea, los procedimientos civiles en línea de la Unión Europea. Así que, sin más, le dejo a Francesco Contini.
Thank you very much. First of all, I'm sorry not to speak Spanish. Being an Italian should be easy. But I studied Spanish many years ago and I didn't practice, and so I'm really, I would mix Italian, French and Spanish in something impossible to understand. And thank you, of course, to the organizer of this conference to having invited me here. It's not rhetoric. There are very few institutions around the world doing the work that we are doing at the Research Institute on Judicial System. And one of these is the Chilean Center. One of the reasons why I'm here is also to identify if it's possible to increase the cooperation between my institute and the Latin American colleagues. Because in comparison to other sectors, like public administration, well, very, very few people are doing this job, and we really need extremely the possibility to exchange information, experiences, and to develop and to maintain the group of people that is doing this job. This is my institute. Ricardo has already shortly introduced me some of the projects. I will speak briefly of this project. What I think it's important to show is that we work in two sides. One is to study the functioning of European judiciary, not just Italy. We are founded by the Italian government, but we are independent. And so we carry out our researches where we think more interesting and more useful. And second is that we study judicial system, we study the changes of judicial system, but we also try to use the know-how that we have collected so far to support judicial reform. And just looking last year I did it at the Seychelles, in Ghana, I'm gonna do it in Kenya now. So we try to transfer the know-how in different parts of the world. We started, well, this is my last book on ICT and justice. This is a book on how to evaluate the performances of the judiciaries, that are the two main drivers of changes that are modifying the structures, the organization, and the functioning of European judicial institutions. And this is where we started from. More than 10 years ago, we got a grant from the European Commission to make the first comparative assessment and analysis of what judiciaries were doing in the field of introducing and using ICT to support their operation. And the results were quite interesting. Almost all over Europe, 1999, 2000, were capable of doing good case management systems to provide information related to case law on the internet or on CD-ROMs, end of the 90s. That they were taking audio or video recording of court hearings. And they were very optimistic in approaching e-justice, e-filing, and exchanging data and information along the criminal justice chain from police to prosecutor, courts, and so on. Well, we made other researches of the same kind in 2003, and well, there were many problems. And when we did the last book, the first one I show you, well, it was clear that there are big problems. And when we have to represent cases, successful cases, of how European judiciary have been able to use technology to change the way in which they exchange data and document with their parties, well, we need to go a little bit in depth, and you need to start to think that it's not just an adoption. The ICT is not just a tool to be adopted, but is something that is bringing changes of a different magnitude into the institutional architecture of courts. And so, to understand this, we have to start from the beginning. And the beginning is the Hammurabi Code. And this is the first pillar, the legal pillar. It's still there. After several thousand years, it's still there. This has been renewed, updated, and in Europe, clearly, arrived Napoleon and did the case file, and did, well, disappeared, yes, and did the court book or the court docket. This is very handy, developed in 2000 by the Italian Ministry of Justice for the justices of the peace. Okay? It's important to show these pictures, I think, because they tell us a lot about the institutional features of the judiciaries that have been untouched until Napoleon in Europe, until 200 years ago. And, oh, sorry, I forgot this. This is the most important. My God. It's not going back anymore. However, you have seen for a second the temple of the law. It's the Supreme Court. It's gone. Okay. Never mind. It was the picture of the US Supreme Court. You know, it could be the same picture of your Supreme Court, the Temple of the Law. The Temple of the Law is the symbol, from an architectural point of view, of that approach. It's an isolated institution, closed, where people go asking for the mercy or for the judgment. It's a self-contained institution. The tools used by the courts are under the total control of the judges and of the court. They can decide which kind of document should be collected within the case file. They should decide the organization of the court book. Well, this was where judiciaries until a few years ago. It's not the case anymore. Judiciaries are not anymore, to say, purely legal constructs, purely legal artifact. They are not anymore bounded and closed. They are not anymore owners of their operation, because they have to rely more and more on third parties to keep running the system. So, case studies. Very few successful case studies until 3 or 4 years ago. Then there have been some progress in Europe. The Finnish guys have been the first to introduce something successfully, probably in the world, because they did e-filing since the beginning of the 90s. Kari Kujanen, that was the chief information officer of the Finnish Ministry of Justice, was a high-level judge, analyzing the situation, discovered that there were a number of summary cases, money order, basically money cases, pending, and discovered also that even if signature was required by the code of procedure, nobody was checking the signature. And say, well, if nobody is checking the signature, do we really need the signature, the handwritten signature on the piece of paper? I said, well, probably no. And moving from this, they decided that email was sufficient to send a petition to the court. Normal email. 1991. So they allowed the use of email, of fax. An incredible increase of the access to justice. Okay? They've been one of the few countries that did this. They did also other things, but just to tell you how a radical change in the regulation can authorize things that make lives of everybody much easier. So the question is why I can write a book with a colleague on the other side of the world just exchanging document by email, and I cannot file a case to court using the same channel. What's wrong with the judiciary? Well, probably I have an answer at the end of the presentation. Another interesting case is Austria. Always at the beginning of the 90s, the Austrian Ministry of Justice started to develop a kind of closed network linking together the courts and the lawyers, the law firms. They developed the system as a closed network. The identification of the lawyers was based on functionalities embedded in the system. The system was provided by private companies, by IBM, still provided by IBM. They started with money order. Very few lawyers in Austria were running a high number of cases, basically utilities and banks that were claiming money. And they started with very few law firms to implement the system. They are going on, they went on with this project since the beginning of the 90s, and now the system has been increased and used for almost all the proceedings of the Austrian judiciary. But there are 3,000 lawyers all over the country. And so you can think to run a closed system with these numbers. But they also received critiques because the system was closed just to lawyers and not taking advantage of the internet to disintermediate it, as was mentioned by the re-railing, and to create new channel to access to the judiciary. And it took roughly 10 years to open the system in order to grant to normal citizens the possibility to file a case. I don't enter into the technological solution because it would be a little bit too long. Because I want to take a little bit more time to discuss of two case studies that are, to me, more interesting today. MCOL and e-Barreau, England versus France. We play with this. Usually we criticize Italy. Today I criticize French. Hope nobody will get offended by this. Okay. This is a soap opera that has to be represented in 2 minutes. This is supposed to be the law firm. This is supposed to be the court. And this is the infrastructure connecting court and the law firms. France is not very successful, generally speaking, in ICT and justice. And various governments pushed a lot to increase the functionalities of the system from this point of view. And the National Bar Association, that in a way superintend to all the local bar association of France, made an agreement in 2000, I have all the data here that as in every soap opera are important, in 2005 with the Ministry of Justice to establish an infrastructure allowing data document interchange between the law firms and the courts. First problem, the National Bar Association made an agreement with France Telecom that provided an ad hoc system that was not compatible with standard DSL technology, that it was and it was mandatory for the lawyers to buy exactly that technology in order to get connected to the system of the Ministry of Justice. It was too expensive. lawyers didn't get it. In the meanwhile, they started to regulate the system. The first regulation has been enacted in 2004. They changed the regulation in 2007. They made it even more detailed in 2010. But the story between the Bar Association and the Ministry of Justice went on. Since nobody was subscribing the system and there were open critiques about the fact that the system was closed and too expensive, the Bar Association decided to open the system, but to introduce a cryptographic box, an additional technology, to be put here in each law firm in order to transmit data on the virtual private network, but that were already protected and made impossible to decodify by third parties. They get rid of the first monopoly of France Telecom, but they introduce another monopoly of the producer of this technology. Lawyers were not happy because they had to pay something like 50 euro per month just to rent the little box. At that point, the Bar Association of Marseille developed a different architecture. Instead of putting the cryptographic box within each law firms, they used the cryptographic box within the Bar Association. So the lawyers were connecting with the Bar Association, and from then to the Ministry of Justice, the data were encrypted. Good? Not good. The company that was providing the little box deactivated the box of the Marseille Bar Association because they were not meeting the security and the safety requirement. At that point, we are talking of lawyer, what they did? They filed a case to a court. And this is where the situation is. In the meanwhile, I don't want to give you too many details. In the meanwhile, the Ministry of Justice had problems in developing their own system. 5-6 years spent in this way. Now there is a very strong political commitment on both sides to develop the system, but after 6 years, the system is used not all over the country and just to access to case management data collected within the court. It's still not possible, generally speaking, then we should be a little bit more precise, but I do not have the time to enter into the detail. It is still not used to file regular cases to court. One of the difficulties, I think, can be appreciated by this. This is France. So the system, as I said, is just for lawyers. And the system has to be developed on one side by the National Bar Association and on the other side by the Ministry of Justice. And has to be developed for each court. And there are, roughly 180 first instance courts in France. That is a large country. So the system has to be duplicated 181 times. Okay? And 181 times the Bar Association has to be involved. If one Bar Association, for any reason, doesn't want to get the system, the Marseille is just one example, well, the lawyers working with that tribunal are not able to use the system. If we go to money claim online, we see a completely different architecture. The user is not a lawyer. Money claim online, by the way, is the system briefly mentioned by Dory Leiling before. The user is not a lawyer, he is anybody. To access to money claim online, you need just a credit or a debit card and being an English citizen. How it works? It works that you get connected with a server provider, with a web server. You enroll into the system. You enter the data of your claim into the system. You don't have to produce the document, but just to declare that a given person owes you a given amount of money for this reason. Okay? At that point, the data are collected by a back office that was already in place in Northampton, in the north of England. They print the claim pack and they serve the claim pack to the defendant by paper. So, until here is digital and here is paper. The defendant receives the claim pack and can decide to reply with the web. There is a password and the username that can use. Or they can decide to use the traditional channel, replying by paper. What is interesting is that judges are not involved. In most of the cases, as was mentioned by Dori, there are judgment by default, because there's nothing to contest. The bill has not been paid, full stop. If there are problems, you can always file a counterclaim and go and take the normal procedure. So in that case, if you say, no, I don't owe that amount of money to that person, the case go to the court that has the territorial competence to handle the case. Identification. This is an interesting issue. It works in this way. At the end of the data entry, the claimant declares his identity and has to pay with the credit or debit card associated to his own name. So they take the identity of the person from the databases of the bank system. Okay? As we do when we pay a ticket to come here with Iberia. Very simply. They did this because the English government was trying to develop in English it's called, sorry, this is in Spanish, UK government gateway. But it was not ready yet. It has been developed roughly 6 years after the launch of Money Claim Online. So waiting for the development of this component that now is granting the identity on different bases, they would have been on standby for 6 years. They have decided a huge number of cases in 6 years without big problems of identity. Another issue, so let's look also at this. This is judiciary, the system of the judiciary. This system has been developed and is currently managed by a private company, Electronic Data System. This is purely private bank system. This is private, the printing facility of EDS that prints the claim and sends it to the defendant. And also the accounting system of Money Claim Online is managed by another independent private firm. This is a public-private partnership. This is something that is not treated, it doesn't stand in the picture of the temple of the law. Here we are talking of a completely different type of institution. If we think to the temple of the law, we are wrong here. Okay? And this has many consequences. And look also at this. One of the bases of a civil law system is that there is, first of all, a territorial jurisdiction. In France, you remember, 181 first instance court, 181 entry points. With Money Claim Online, they did this. One jurisdiction for the entire England and Welsh. So basically, Money Claim Online works as a unique entry point. It handles the case digitally if it's undisputed, or with some other exceptions. If the case is disputed, the case went back to the normal jurisdiction. But, as mentioned by Dori and by those that developed the system, the large majority of these cases are undisputed because there is nothing to dispute. And so Money Claim Online handles 70% of the money claims filed in England and Welsh. The idea of taking advantage of the digitalization to move from a detailed articulated territorial jurisdiction to a national jurisdiction is something that is in a way embedded. If you buy a ticket with last minute, they don't have an office in each city. They have just an office who knows where, and you just interact with this web server. And until when you don't have to go back to the normal judicial proceeding, you can stay on the digital domain. So if we look in a comparative fashion to eBarrow and Money Claim Online, we see some similarities and some difference, basically. eBarrow is close to lawyers. They are trying to use ICT to reinforce the legal monopoly of lawyers to us in the access of justice. In Money Claim Online, it's completely different. It's open to lawyers, it's open to anybody. In Money Claim Online, instead of looking for the super secure, strong version of digital signature, PKI based on EU regulation, etc., as many other European countries. They used the data already available. They used the technological components that were already ready at hand. In the French case, they started to develop many components from scratch. And they are still trying to develop these components. It's like if today I have to go to the airport, I take the streets that are already available. If I think that the streets are not secure enough and I need a railway to bring me there, well, probably in 10 years there will be a wonderful railway, but it takes 10 years to develop the infrastructure. And maybe the infrastructure is so expensive that the bill or the cost of the ticket is so high that nobody wants to take it. So here we have to start to think in a different way. We have to start to think to the fact that we are not developing systems that are closed within the court or within the prosecutor office, and you can force the use of the system because you have the authority to do that. You have to create the condition to attract the users to take advantage of the system. And in money claim online, it happens because you have just to pay the court fee with the credit card because the access is very simple. In Ibaro, the same lawyers are not willing to buy the technology. And the same story happens in Italy and happens in many, many other countries. So we are not we say that we don't talk anymore with closed systems, with self-contained technologies, but with information infrastructures. And information infrastructure are the result of public and private. The last point to highlight here, and then I want to also go to conclusions in order to leave some time to questions, is that Money Claim Online is, in a way, a ready-at-hand application. You just enter into the web, and you see Money Claim Online, and you start easily to use the system. No more documents. You don't have to present documents unless the case is disputed. It's really like to like to buy a ticket. If you want to go ahead enforcing the traditional exchange of documents based on a paper document, the signature, and all the components that have arisen in the normal judicial procedure until, let's say, 15 years ago, but may not have a reason of existing in the new digital environment, well, you have to develop the technology to follow the conventional procedure that are not suitable in most of the cases to be easily digitalized. Okay. Let's skip this and look just at this issue. Functional simplification. If you think to judicial procedure, they've been, in a way, the result of many years of stratification, of adjustments, of change, and often are quite complex. When the people that designed Money Claim Online started to work with Money Claim Online, did a radical functional simplification. So they identified the single segments of the procedures that could be easily transformed into an automated data and document processing, and they used just that. You remember that if the case is disputed, it goes back to the normal court. Well, this is how functional simplification works. Not everything can stay online. Just put online what is simple or can be simplified to the point that can be handled online. But since in Europe we are limitless in terms of challenges, despite the lessons that are coming from the field, we are trying something even more difficult. We have this project that is building interoperability for civil proceedings online, because now the European Commission is trying to implement through ICT a kind of European civil proceedings for injunctive order for money claims. And it is something almost impossible, because you can imagine that we have 27 different legal and juridical systems. We have many different technological systems running in each country. We have 27 even more languages. they want to use technology to solve problems that are not technological. And this is a common mistake. Technology cannot help in this. If I have to file a money claim in the Netherlands, no doubt I have to hire a Dutch lawyer, and I have to work with a Dutch lawyer. I cannot, as individual citizen, file the case in Italy, hoping that will reach the right court in the Netherlands and will be handled in the right way by the judge. And this is, I think, an example of the kind of problems that technology cannot solve. They don't want to have a European court dealing with trans-border cases. Fine. But don't think that technology can route the case, can can solve the linguistic problems of 27 languages, can, in a way, transfer the case to the right court in the right way, because this cannot be done by technology. Now, conclusions. Okay, 2 minutes. Yeah, 2 minutes. I'm in time. Oh, I started at 15. No, 20. So, we started technology as a tool. Technology is not a tool. Technology, I think, it's a carriage of institutional reconfiguration. Technology brings into court market mechanism or a huge number of companies, of private companies, and this can be good, can be bad, we don't know. Certainly there are problems of keeping the market open and of keeping the possibility to change technological providers. And this is a problem in England, is a problem in Austria, is a problem in Italy, is a problem in many countries where a company starts to work with the judiciary and becomes slowly, I'm not talking of corruption, I'm talking of healthy system, but they develop a specific know-how with the system that when there is the new bid, they have a first move advantage that cannot be solved. And so we are having, as in England, that EDS and other private companies are working hand in hand with the judiciary, and so we don't have anymore the temple of the law. Judiciaries are not anymore self-contained. They are integrated with this bunch of institutions, and the operations are based on, on a composite set of technological, legal, organizational elements that are not those that I was trying to represent with the picture of the temple of the law. They are becoming, what I wrote in English, unbounded platform for judicial dispute resolution based on standard and modular components, credit cards, printing facilities that can be used by the court as well as by a bank, whatever. And here we have the temple again. They are a mix of bureaucracy and market. We have short-term contracts with long consequences. We do not know if managerial methods are increasing the efficiency of the judiciary, based on the research we have conducted so far. And finally, the technology is really becoming a carriage of institutional reconfiguration, not just a means to an end, not just a tool, but something that is changing the real root of the judiciary. This is how a European judiciary represents the new model court, the temple with computers plugged into the court. I think that this is wrong. We don't have computers. Each computer brings in private companies, brings in long-term contracts, brings in different logic, brings in monopoly versus open market. Sorry. This is Singapore Supreme Court. It's not anymore the temple of the law. Next time I will use also this building, because this building has the same feature. It's more like a web of relationship between the court and the environment than a temple. But we even should think to something like this, that is not a court, is the museum, Guggenheim Museum in Bilbao, but if with the picture I can envisage how courts should be in 10 years, I think that this should be the way in which courts are. Thank you very much.
Bueno, la verdad que tenemos muy poco tiempo, tenemos apenas 10 minutos para las preguntas, así que vamos a hacer una ronda muy corta de preguntas. Natalia.
La traducción a la pregunta, o hago la pregunta en inglés o en español. I was going to say, I had a question regarding your EU issue. Private institutions have also encountered the money online issue. I think eBay provides a very good example. And they've had to deal with multiple cultures, multiple languages, and found an approach. Has that in any way been looked at in the EU or any other governmental system, the way that private companies are approaching the same issues? Because eBay has created a fairly strong crossover mediation arbitration with these type of issues. And so I was wondering if these private examples are in any way being applied in the public sphere.
¿Alguna? One more?
Yeah, no.
Just one more. ¿Alguien más quiere preguntar? Ok.
Is it working? Yes. eBay is a good example of different ways to solve disputes. There are other examples in more specific areas, but nobody is considered this as example to be implemented in some way or supported by the European Union. We still think to ourselves as 27 member states, each one with its own institutional, legal and juridical peculiarities that has to find a way to collaborate, but they don't think to something like this. So with the project building interoperability, we will suggest to create some intermediate board, because you cannot think to have collaboration one-to-one 27 times, because it's too complex. The problem is institutional, is that the European Commission or the European Union doesn't want to grow anymore in terms of structures. And they hope to transfer to technologies things that cannot be transferred. And so this in a way is the trap in which this kind of techno-institutional problems are based, are now, basically. Just to provide a very quick answer. Dori, maybe you want to add something?
Now the question is this one working? And it is, yes.
Yeah.
With regard to the eBay functionality, that I have seen it, and it is basically, it facilitates communication between two parties. So it might help. That kind of functionality might help, let's say, in a pre-judicial phase. That, by the way, also goes for money claim online, because the first advice, if you go to money claim online and you file a claim and you are actually presented with a claim from somebody else, the first advice you get is, if you think you owe the money, go and pay it. Or make an arrangement with the other party that you can pay in installments, for instance. And that already takes care of a lot of the cases that come there. And this is something that eBay could support. When it comes to dispute resolution, things become a little more complicated, because dispute resolution as a process is, as you've seen from my picture, is more complex than just a dialogue between two parties about who does what.
There is a strange problem of privacy also, an incredible protection of privacy in Europe. So reputation, that is the mechanism used by eBay to reduce transaction cost and in a way solve dispute or facilitate the way in which disputes are solved. It means that when you accept to transact in eBay, your data should be made available to third parties. If you are judged by Dory Railing, or I don't know if it's the same in Italy. In Italy, certainly this, and also in France. And the sentence is published on the net. The name of the person or of the companies judged by Dory or by an Italian judge have to be cancelled. And this is crazy, because reputation is a great means to reduce transaction cost and to identify good potential commercial partner or bad ones. And for some reason, and this is a legal cultural issue, I think, in many European countries, this is not possible.
From what I see on eBay, this is a very interesting discussion about eBay, is that they now protect the identity of, for instance, if you bid, you cannot see the identity of the other bidders anymore. That is something that they changed, I think, about 12 months ago. So that has been changed. And with regard to privacy, if you are a company that comes to my court and the decision is published, and we are publishing about 20,000 of our decisions every year now, and it's increasing. If you are a company, your name is published. Only if you are a private person is your name not published. And there is a debate about that. So.
And I was not talking about family cases, of course. I'm talking about commercial cases, and also Doris said I'm talking about commercial cases.
Bueno, agradecemos entonces muchísimo las exposiciones de nuestros dos expositores. Creo que fueron muy interesantes para los países de la región. Y para contarles un poco, ahora tenemos el receso de almuerzo hasta las 2:30. Yo sé que es un poco ajustado el tiempo, pero para que terminemos también temprano. Y a la vuelta entonces seguiremos con nuestros paneles de experiencias de implementación de tecnología, tanto en la justicia brasilera como también en Costa Rica y en Colombia. Así que los esperamos entonces a las 2:30.